This is the psychologist's response to the child's essay. The school gave her father the essay. He then made copies and gave one to a PhD clinical psychologist. The psychologist's letter is dated April 16, 2004. To whom it may concern. Based upon the numerous factors and apparent from the attached essay, I was obligated as a mandated reporter to report via the New York State Hotline abuse of the child on April 13, 2004. A clinical analysis of the essay indicates that the child may be facing imminent and irreparable harm in various forms. Damage to her character and personality is the most probable and likely form of harm. The mistrust of counselors, legal representatives, including the judge in this case, her law guardians, and others, as well as her mother, suggests that this adolescent is vulnerable to forming a character disorder or related condition. The terrible pain the child is experiencing, as expressed by her written word, might exasperate her feelings of frustration and depression, from which she may never be able to recover. Additionally, the child may decide to find a way to escape the pain and other distress by harming herself. I expressed the above concern in more detail to Sandy Snowden, CPS supervisor assigned to this case, and to Diane Foley, the child's law guardian. They both appeared concerned and well-meaning and entered into a sincere and meaningful dialogue about the situation. Ms. Foley expressed the point that Thomas had not fulfilled certain court mandates or stipulations, and therefore the visitation requested by the child might not be possible. However, the basis of my report to CPS was that the child was suffering abuse and possible imminent and irreparable harm, specifically because she was being prevented from seeing her father, who she loves and trusts. The psychologist then printed the following in bold letters. Why should the child be punished because Thomas, her father, did not complete or fully comply with the court orders? The court is using the child to punish Thomas, and further, it is using Thomas to punish the child. Thomas's conduct has no bearing on the child's needs at this time. She didn't disobey any orders, and she should therefore not be denied her yearning to be with her father. One further point. On July 15, 2003, I accompanied Thomas, the president of the chapter of the Children's Rights Council, Elizabeth Sheedy, and David Friedman to a meeting with Judge Jacqueline Silverman, the chief matrimonial judge in New York State. The meeting reviewed Thomas's case and was held on the record. I had examined Thomas prior to that point in time, and I informed Judge Silverman that I considered Thomas to be a fit custodian and a caring and loving father. I affirmed these findings at this time. I am an experienced clinician, a forensic evaluator in Nassau County, and I have been qualified as an expert numerous times in all the Supreme Courts and family courts in New York metropolitan area. I believe that we are faced with an unbelievable set of circumstances. To wit, a young teenager is begging and pleading to see her father, who she loves and trusts. She is heartbroken and depressed, and most of all, she is suffering extreme distress because she is being prevented from having a significant interactions with her father. Her father is ready, willing, and able to meet her requests and her needs, but the legal bureaucracy will not allow it. Therefore, it is my conclusion that something is very, very wrong with this system. It is my recommendation and my hope that the child's needs, so well expressed in her essay, will be met very shortly. If not, I must repeat that I fear for the consequences that she will experience. Thank you for your time and considerations. I received a copy of each on May 4, 2004. As of that date, nothing had been done. This is how the courts treat children that want and need to have a relationship with their father. Who is the law guardian representing? The child or the mother? According to the father and the child, the law guardian is representing the mother. Here, her client is demanding to see her father, and all the law guardian seems to worry about is whether the father has jumped through all the hoops the court wants him to in order to see his daughter. I should mention the father has custody of his two older sons that his daughter refers to in her essay. Why is this father on supervised visitation with his daughter? Certainly she's not fearful of him, and she wants to be with him. Is it because the court wants the child and the mother and the father paying child support? When you read the father's case, you will see the court is holding the child hostage. The court does not care what happens to the child. All the court cares about is the mother having custody and the father paying child support. The judge in this case needs to be removed.